Professor Lunny and try and get some clarity from, or as it relates to some of your written testimony on pages 6 and 7. Bottom of page 6, you state that, as has been previously discussed, the purpose of copyright is not to maximize the revenue of the music industry or copyright owners more generally. Is that correct?
Yes, sir, I do take those statements from Supreme Court decisions setting that forth and repeat them.
Now, is it fair to say that copyright owners or content creators are entitled to reasonable compensation?
I think we'd have to sit down and define what reasonable is, and that would be a more difficult task than you might imagine.
So you don't take the, is it your view that copyright owners or content creators are entitled to any compensation whatsoever?
No, it's not my view of that sort at all, and I would be happy that they would be very well paid. My only perspective is that in terms of the constitutional purpose, our focus should be on the production of output. Now, obviously, a well-compensated artist and musician class is probably important for long-run copyright output of creative works.
Okay, let's focus on the Constitution. I appreciate that observation you just made. So the relevant provision, obviously, is Article 1, Section 8, Clause 8, which reads to promote the progress of science and useful arts by securing for limited times to authors and inventors exclusive right to their respective writings and discoveries. Now, the progress of science part of that provision obviously gives Congress, I believe, the ability to create a robust patent system. Is that correct?
It's actually the promote the progress of the useful arts is for patent. Science is for copyright.
So you've defined the, right, and what would be the basis of that conclusion? Does that stem from your evaluation of writings from the Founding Fathers, or?
Supreme Court has said that on a number of occasions. The clause has a parallel structure to promote the progress of science and the useful arts for authors and inventors, their writings and discoveries. Each of those three pairs of words, the first word is for the copyright, the second word or phrase is for patent.
And so the Supreme Court has defined this standard, I believe, to encompass two legitimate ends, correct? The first would be encouraging the creation of new works. Is that right?
That's correct.
And then the second would be to encourage the dissemination of existing works, correct?
That is what the court said.
So now, as it relates to encouraging the creation of new works, is it fair to say that providing artists, content creators, with the opportunity to benefit from the fruits of their labor in some meaningful way serves the purpose of encouraging the creation of work?
As a general proposition, I have no disagreement with that statement.
Okay. And what would you disagree with as it relates to that statement?
Well, it's always a question of how many rights and how broad the rights need to be. Do we need to address every specific instance? In the Academy, we talk about leakage in the copyright system. That is, instances where individuals or companies copy and yet they're not sued or it would not constitute copyright infringement. And this leakage is a fairly important part of the system. So trying to determine whether any given instance of copying, some are reasonably straightforward. I would agree, I think we would all agree, that a commercial competitor who takes a copy and sells it for less in the same marketplace is a copyright infringer. I think we'd all equally agree that someone who takes Shakespeare's Romeo and Juliet and creates West Side Story would probably not be a copyright infringer.
And am I correct that, you know, it's your position as it relates to determining the measure of what happens when meaningful or reasonable compensation is not provided, is that we should simply allow for the illegal dissemination or reproduction or sharing of works and then evaluate whether content production has decreased? Is that your position?
No, I'm not advocating sort of randomly changing the law to see what happens. As a social scientist, I might be interested in that experiment. But file sharing gave us an opportunity to see what might happen. It was formally illegal, but it nevertheless happened, and revenue to the music industry, even considering all the revenue sources they have, definitely went down. So what happened to output? And what does that tell us about whether we had not enough copyright, too much copyright, or just the right amount? And if revenue goes down sharply and your copyright protection effectively falls, and yet you seem to get as much or more creative output, for me that suggests that we may have had too much copyright to begin with.
Should we be concerned about the impact on the economy in that scenario?
Well, it depends on what you mean by the impact of the economy. For me as an economist, the fact that some money doesn't flow to the music industry, it's going to remain in the consumer's pockets. It's going to be spent elsewhere in the economy. Jobs lost in the copyright sectors will presumably be picked up if consumers spend that money on education or employment or health care in those sectors of the economy.
Lastly, Professor Nimmer, you referenced earlier in your testimony that facts change on the ground. And I believe you may have mentioned it in the context of misinterpretation of a line in a treatise that you had prepared, which preceded the development of Napster. We've also seen the advent of streaming. Cloud computing is another example. Technology changes over time. That's a wonderful thing. I think many of us would agree. The issue is, how do we accommodate technological changes as they move forward, but also create the certainty in the law and the copyright protection for the creative community? Do you have any words for us on the committee in terms of how to strike that appropriate balance, if that is the balance we should be seeking?
I certainly do agree that it is the right balance. At the end of my written statement, I reproduce one page from 50 years ago. It's from the Register of Copyrights, written in 1965. And it said, we don't know what the law will be 10 or 20 or 50 years from now, and they're writing 49 years ago. But they said it is becoming increasingly apparent that transmission of works by linked computers may be among the most important means. And the final statement was, we believe the day is past when any particular use of works should be exempted for the sole reason that it is not for profit. So those are very wise words to guide us as we go forward. This was written at the culmination of 10 years of study, and I think it beautifully encapsulates much of the philosophy that needs to go in. So that would be my watchword for Congress on a going forward basis.
Thank you. My time has expired. I yield back.
Thank the gentleman from New York. Professor Lunny, I owe you a belated apology. I previously mispronounced your surname. You are not Looney. I stand corrected.